ready?
Not yet.
Okay.
We're live.
Good afternoon. This is the House Judiciary Committee. It's our voting session here on the 19th of February, 2021. We're going to begin today with House Bill 71. So we normally would go in numerical order. We're going to go with House Bill 71 here. And we're doing that because we have joining us, sideways, is Delegate Eric Lutke, the Majority Leader, who is here along with his aide to address any questions people have related to House Bill 71, which we share with Ways and Means. There are, I think, 2 amendments, if I'm not mistaken. Lauren, are you there?
Yes, that's correct. There are 2 sets of amendments. The first one, Dylan, is showing there that says page 3.
All right. Can we talk about what the amendments would do first? And I don't know if Delegate Lutke, you want to do that, or Lauren, can you do it? Or
I'm happy to start and then Delegate
Yeah.
in if I'm mistaken. Okay, so the amendment that you see on the screen, this is just ensuring that employees of the Juvenile Services Education Program established under the bill remain in the employee pension system.
Okay. And then the second of the amendments on House Bill 71?
The second one, so Dylan, that's the next 3 pages.
Yeah.
They do several things. First, they're adding an educator member to the Juvenile Services Education Board and providing for the election of the member. They are authorizing rather than requiring the county boards of education to waive high school graduation requirements for committed juveniles who return to the local school system during the 11th or 12th grade. They are adding a reporting requirement by the Juvenile Services Education Board regarding dual enrollment of students with IEPs, and reporting on some funding mechanisms. And lastly, they're providing for the transfer of personnel to the Department of Juvenile Services.
Okay, so let's do this. Delegate Lutke, would you please give the committee an overview of what the an overview of the bill and the posture the bill is in, and you can do it with the amendments added in it. But go ahead.
Yeah, and Brad Fallon from my staff is here. He's been working very closely with a number of the different organizations that have had opinions, and that's what produced this set of amendments. But I mean, to take a step back to the 10,000-foot view, what this bill proposes is to take the juvenile services education system, which is currently treated differently from any other set of schools in the state of Maryland, because there is no school board, there is no oversight body that is directly responsible for them, aside from the State Board of Education, which obviously has a very different role in most cases. To put them under the control of a separate school board with their own superintendent. For logistical purposes, that school board is housed within the Department of Juvenile Services, but the Department of Juvenile Services will not have any control over the curricular decisions and other educational decisions. Those will be in the hands of educators. It's being located at DJS so that things like procurement and human resources processes and those kinds of things can be handled through existing structures, which helps mitigate any fiscal impact. The series of amendments came in part out of conversations with employees of the juvenile services education system and some of the concerns that they had expressed. The last time the system transitioned was a challenging transition for a lot of them. And so they had asked for some specific protections in the bill. The most important of which is that the amendment language would not allow this new school system to zero-base staffing. They wouldn't just be able to say everybody's fired and you have to reapply. These employees, many of whom have served the state with distinction for years, would be able to keep their jobs now. The new system would be able to go through the normal process that's defined through collective bargaining agreements and the law for removal of an employee, But the default would be that people would keep their jobs.
All right, let's do this. If anyone has questions, you can raise your hand electronically using the Zoom. Delegate Jones with a question, her very first one.
Yes, okay. So thank you, Sir Chair. Delegate Lukey, my question is, you said that DGS would not be responsible for making those decisions, educators would be. So Cheltenham is a state, juvenile facility in my district. Does that mean that Prince George's County school system educators, who are those educators who would make that decision? Is it by county based on where the facility is?
So the way the system currently works is that the JSES schools are completely independent of the county systems. They're administered by the state Department of Education, and the employees are employees of the state. And that creates a number of problems that, frankly, we're trying to address here. For example, these employees, in some cases, in places like Prince George's, Montgomery, Howard, they often make less for 12 months of work than a K-12 educator in PGCPS or MCPS makes in 10 months of work. And that's one of the core issues that we're hoping this transition will eventually address. When we started these conversations 3 or 4 years ago, we were essentially looking at 2 different models. One of them is a model where the local school system would take over the educational programs in a facility within the county. The other one is this model that we're proposing in the bill where there's a new school board. We ended up going with this new school board model in part because it will allow this school board to be composed of people who specialize more in the issues that are unique to students who are in institutional settings. And in part because, the capacity of different school systems to absorb new programs is different. But all of that said, one of the key problems in JSES for years has been challenges in communication between local school systems and the juvenile services education system. And frankly, I think some of that is structural. Some of that has been on some of the school systems. Some of that has been on JSES. I think that's one of the things that this board will have to think through and negotiate as they're sort of taking over the programming. But to your question, who are the educators? So this board will be appointed. The members of the board are delineated in categories in the bill. They will then select a superintendent. That superintendent and their staff, like any other school system, will be making the educational decisions for these facilities.
And they'll be appointed by the state?
So the superintendent, just like any other school board, just like most school boards in the state select their superintendent, the school board will select a superintendent. Okay.
I just want to clarify. Mm-hmm. The state school board will select the county.
No. So this new school board we're setting up that will only administer the juvenile services education system will select one superintendent for all of the juvenile services schools.
Gotcha.
Mm-hmm. Sure, no problem. And welcome, by the way, and congratulations. By the way, we like to joke, me and Eric Barron and Eric Ebersol, about there being an Eric caucus in the House, but I think you all have a Delegate Jones caucus now.
Yes, we do now. Yes.
Delegate Grammer.
Thank you, Mr. Chair. Delegate Lukey, good to see you. Could you touch one more time on the labor parts of this bill? Did it change the collective bargaining agreements? Is it just renewing them? Is anything different in the move?
Yeah. So, and this has been not all of the employees of JSES are currently union members. In fact, one of the conversations, and I should take a step back and say, the start of a conversation, right? This board will exist for more than a year before the actual transition happens. And I can guarantee we're going to have work to do in the future to continue to support these schools and make sure they are the best educational programs that they can be. There have been issues with special appointments of employees within the JSES program, which has frankly, I would characterize it as a workaround that has prevented people from having the same protections that other employees would. But the majority of employees within the system are represented by the Maryland Professional Employees Council, which is an affiliate of the AFT. Their collective bargaining agreement would continue to be in force as it currently stands until a new collective bargaining agreement is negotiated between this new school board and the employee representatives. The employees would continue to be in the educator pension system. They would gain the same protections as other educators have in a variety of components of state law. They would, I'm not sure if, am I going too deep?
Yeah, when I read it initially, it seemed as if it just specified that the agreements, they continue. That's the way I read it. But when you were talking, it sounded as if there was a movement from one system to another, or there was people that were not previously covered were now covered, and that's what I wanted to clarify.
No, I mean, so one of the valid concerns from the employees was, if this transition happens, does that mean their collective bargaining agreement is no longer in force?
Right.
And obviously that would not be frankly, not a good situation for anyone, not the educators, not the folks running the system, because collective bargaining agreements help define, the work. And so we essentially said, keep the agreement you have now applies until you negotiate a new one, and then that new one is the new agreement.
Okay, and is there anyone that's newly moved into that system?
What do you mean? Like folks that currently can't bargain, but would be able to?
Correct.
Not under the bill as currently written. Brad can correct me if I'm wrong, but not under the bill as currently written. I do think, frankly, I'm going to be upfront with the committee. I'm planning to come back next year with a bill to deal with the special appointment issue, because I'm a strong believer that you treat your employees the same, and so I have concerns about people being put on special appointments for in some cases years, when they should have the protection of collective bargaining agreements.
Okay, thank you.
Delegate McComas, and then I'm going to take a motion on amendments. Delegate McComas. You're on mute.
Okay, thank you. Delegate Lukey, I have a question. When I was reading the fiscal note, the current employees are going to stay in the lower percentage system until their collective bargaining ends, and then they switch over to the educational system, which is a better system. Is that correct? The way I understand?
That's the goal. I would hope that, one of the consistent challenges that JSDS has had, God bless the people that work for the system, right? Because they have not received the same level of support in a lot of cases that we see in some other school systems in the state. And I don't blame any of the folks in the system right now for that, right? Like, that's a structural issue. But yeah, the idea would be that they would, because they have a new school board, they would be able to negotiate a new agreement that's specific between that board and the collective bargaining unit. And frankly, I would hope that agreement would do a better job of providing compensation and things like that.
Because when I was reading it, it sort of looked like these folks work 12 months out of the year, and they don't get the 3 months or the 2.5 months or whatever it is. So really, they have been, it sounds like, underpaid, maybe.
Yes. They have been and are underpaid. Frankly, for somebody who works at one of the facilities in Garrett County, for example, the wage is a little bit more comparable, but certainly the schools that are in the central part of the state, you make more money in a lot of cases, if you leave the juvenile services education system and go to a county school system, and you're also a 10-month employee instead of a 12-month employee. These people should be paid more, much more than a regular classroom teacher, for a whole host of reasons, but not the least of which is their schedule is different.
Thank you, Mr. Chair.
Thank you. Is there a motion on the amendments?
Move the amendment.
There's a motion to move the amendments and a second. All right. Is there any further discussion on the amendments to the bill? Seeing none, all in favor of the amendments will raise your hand and say aye.
Aye.
Anyone opposed? Seeing none, the amendments are adopted. Now we're on the bill as amended. Could I have a motion on the bill as amended, please?
So moved.
There's a motion for a favor on the bill as amended. Is there a second?
Yeah, there was.
Oh, I thought I heard a second too. All right. I think I heard Delegate Bartlett with second. And
It
Delegate,
was, what, Delegate Williams?
that's fine. Delegate Williams with the second. All right, there's a motion for favorable and a second. Any further discussion? Seeing none, roll call. The Vice Chair,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones. For the
Yes.
first time ever, yes. Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Sham,
Yes.
Williams,
Yes.
and I think that's 21. No, that's 20 because we're down Watson. So, okay. Thank you very much, Delegate Lutke. We're going to go back in the regular order here. I've got to say, you can see Delegate Lutke is not here in Annapolis, or you might not know that, but he's not here in Annapolis. And I get to be the stunt double to be the majority leader, apparently at 3 o'clock to stand in for the pro forma session. So if we don't by 2:55, we're going to have to come back. It's not a threat. It's just that we'll have to come back for a few minutes. And with that, let's go to House Bill 3 because, hey, why not? We handled this bill in 2019. This bill removes the governor from the parole process.
Motion favorable.
There is
Second.
motion for a favorable and a second. There are no amendments to the bill. Is there discussion on the bill? Delegate Cox.
I just wanted to say thank you, Mr. Chair, that normally I would vote for a bill put forth by you, and I just, I'll be voting no just because the fact that this will remove power from the governor, so. No.
You don't have to suck up. You don't have to add that, Flowers.
All right, stop it, stop it. All right, Delegate Malone, please.
I just would like to point out to all that Governor Hogan has made 26 individuals who were lifers on parole. I believe 9 of them were medical, and he's also done 24 commutations. So I just find it interesting. We're looking to remove the power from a governor who I believe is very much exercising appropriate power, and that's not sucking up. It's pointing out that he has followed a different path than previous governors.
All right. Is there further discussion? I see no one else's hand is raised.
Delegate Carden.
Delegate Carden.
Delegate Carden, I didn't see him raising his hand electronically.
Thank you. I was trying to find the electronic. I just wanted to, in response to Delegate Malone, that perhaps this has been an issue that's been going on long before Governor Hogan became governor, and previous governors have shown, even regardless whether they're Republicans or Democrats, that some of them have the courage to look at these issues with some progressivity, and some just do not. And the previous governor, with all of his good aspects and bad aspects, did not do what this governor did. And I would say that this really applies to somebody like that as well. So while this is a tough bill, because I always think that we should give discretion to governors, I'm going to support it because I think that in the end, the administration is probably going to be happy not to have to deal with these.
Is there further discussion on the bill? Seeing none, we'll take a roll call. The Vice Chair,
Yes.
Anderson,
Yes.
Erican,
No.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Nay.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
No.
Williams,
Yes.
13 to 7. Okay, thank you for that. We'll go now to House Bill 48. There is an amendment, and the amendment, I'm putting in the amendment after listening to the conversation during the bill's hearing. Delegate Davis expressed some concerns about the two options that were available for this would be a person who has been convicted of an offense and has been put on the sex offense registry. Because they're on the sex offense registry, they cannot go to a school, but they may be of an age where they were still able to go to a school. So for example, they were 18 or 19 and they could still go to high school. So the idea behind the bill was to say there was a situation in Baltimore County where a kid went back to school despite the fact that he was on the sex offense registry. So the idea here is to provide another option other than a traditional school for those people to go to. So what the bill says already is that it has to be a location other than real property used for a public or non-public elementary or secondary education. The bill said by participating in the home and hospital teaching program for students, or by participating in or by going to a regional institute for children and adolescents. Delegate Davis pointed out that that would basically leave an option of either between home and hospital or going to what effectively is a lockdown facility. So we've created another option that says that the student can participate in a program approved by a county board. So in other words, it would give the county board the opportunity to set up a system if they had a person who was a sex offender but was completing their high school education. The county board could then figure out an alternative situation. That's the amendment. I see Delegate Arakan has her hand up. I believe she's the only one. Yes, Delegate Arakan, please.
Thank you, Mr. Chair. So yeah, this amendment, I think, covers the concerns that we had about that situation. And did we run these by the sponsors?
Yes, Delegate Bhandari. I spoke to Delegate Bhandari. I did not speak to Delegates Jackson or Mangione, who had a similar bill, but I did talk to Delegate Bhandari, and he had no objections to it.
Yeah, I mean, I think this makes sense as long as the program approved by the county could not be one that was inside. So as long as this line makes it so that there's no way that later the county could reapprove a program inside the schools.
Right, with other people, right. So that was the problem with the bill last year, is it set up a sort of a feedback loop where the kids couldn't be in the school. The kids couldn't you couldn't go to school, but the kids could, have the opportunity to go to the school, but they couldn't go to that school. But if you sent them to an alternative school, they were still going to a school. So the idea here is to give the local school boards the opportunity to set up a program for those specific kids. How many kids we're talking about? It's not going to be it's not that big of a number. So it'll just be it just gives the counties some greater flexibility to deal with it.
Okay, so, all right. So for sure, there's no feedback loop here then.
I don't think there's a feedback loop here anymore.
Okay, a location other than real property, and then by stipulation 1, either home.
It
and
would allow
hospice
them to do
or-
virtual learning effectively.
Yeah.
The county would have to set up
Yeah, I was just wondering if maybe a virtual program, if adding the word virtual in front of program might make sure they don't get away with saying, oh, well, we're following it because we set up our own program.
I think the rest of the bill is fairly clear with that. but.
Okay,
uh,
okay. It's up to
I'm
you. I
open.
mean, I trust your
Yeah.
judgment on it.
Delegate Deborah Davis.
Thank you for your consideration of my concerns. I do have just one question. I know that in my county, we have special facilities set up, but they're on the real property owned by the government.
Right.
Is that going to preclude me from having a special facility on property that we already own?
No, I mean, here, the challenge was the person who is on the sex offender registry, the number of which cannot be more, definitely can't be more than 100, probably less than 50, of somebody who is still of a high school age, who has been convicted of an offense that puts them on the sex offense registry. So it's basically saying if the county puts together, we had to get away, they can't go on school property to begin with. So they can't go there anyway. So it's basically with this amendment, it's allowing effectively 3 options. The county board can set something up virtually because they won't be able to go onto the school property anyway. So it'll enable the county board to set up that virtual way forward, or they can use home and hospital, or the other option, which, as you pointed out, is more of a lockdown option. So probably not the best, but we'll leave it there just in case. But having said that, it just gives them the flexibility to set something up for them, knowing that they would not be able to go to the school, to a physical brick and mortar school in any case. That's the argument.
Move favorable.
All right, there's a motion on the accepting the amendment. So I hear Delegate Arakan moving favorable on the amendment. Is there a second to the amendment?
Second.
Motion and a second. All in favor of the amendment, raise your hands and say aye.
Aye.
Anybody opposed? I don't see anybody opposed. Okay. We're on the bill now as amended.
Move favorable.
The motion for a favorable and a
Second.
Second.
all right. Further comments? Delegate McComas?
Just real quick, a lot of times the schools are used for park and recreation activities after the school hours. And, some that go to the school, go to them. I was just wondering if this pretty much, at least in Harford County, does that seal this so that these kids that are sex offenders won't be able to go to the school at all?
That's separate. The kids who are on the sex offender registry already can't go to a school building.
Oh, okay. All right. Just
This
wanted
is-
to make sure that.
No,
there
no,
was-
you're fine. This is
Okay.
just the small universe of people who could be students presumably at a high school who are
No,
on the sex offense registry. Right. Okay.
I'm sorry. I just wanted to make sure.
You're fine. You're fine. Okay, there was a motion and a second, and I don't see further hands. We'll do a roll call. The vice chair,
Yes.
Anderson,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Williams.
Yes.
All right, that's 20. We're now going to House Bill 277. This is the vice chair's bill. There are no amendments that I have. Is there a motion?
Move favorable.
Motion for a favorable.
Second.
I'm
And a
sorry,
second.
which bill is this?
277.
Thank you.
Does anybody have any comments, any questions about 277? Seeing none, the motion is for a favorable. There has been a second. We'll go and have a roll call. The vice chair,
Yes.
Anderson,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Sham,
Yes.
Williams.
Yes.
20 votes, 20 to nothing. I wonder if this is the only committee that has 3 people who share last names with other people in the legislature, because I've just been, okay, sorry. All right, everybody, it's gonna be fun now, because it's a jump ball. It's a jump ball, 2 parts. We're on House Bill 411, and been a fair amount of discussion, at least between me and Delegate Williams and others. So we're going to put it to the committee. So there are going to be 2 amendments here. The first of the amendments is on your screen now, and it reflects changes to the bill as it was introduced that came out of JPR that I would say clarify the bill somewhat. And Delegate Williams, if you want to talk about what this does to the first half of the bill, why don't you go ahead and do that?
Thank you, Mr. Chair. Yeah, so the amendments just pretty much match most of what came out of JPR. And so it just simply, I guess the biggest change is really just stating that during the course of the investigation, if the law enforcement officer knew or should have known that the person is a victim, witness, or suspect in the investigation, then obviously they should not be engaging in any type of sexual contact with that person. So that's probably the biggest clarifying thing. The other thing was in front of investigation, just the word open, just to specify that this is related to an open investigation as opposed to closed investigations, and just clarifying person. So that's pretty much the amendment.
All right,
Move the amendment.
there's a motion for the amendment. Is there a second?
Second.
There's a second to go to the amendment. Now, before we go a little further here, there is going to be another amendment that's going to be put forward by Delegate Moon here in a moment. Delegate Moon will be addressing the second part, and you go ahead and roll it up if you'd like now. Delegate Moon's amendment would remove the part of the bill that says, that leaves an exemption it says that if a officer was already in a relationship effectively with a witness, that they wouldn't be breaking this law. And we'll get to that in a second, but for now, the first amendment would conform the first part of the bill to what JPR passed. With that, Delegate Arakan.
Thank you, Mr. Chair. So with, if you could scroll back up to the previous
Dylan.
amendment. So with this, all right, let me see, would this amendment be just for if the officer was involved in the investigation, or just what if the person was under investigation in a totally different precinct in a totally different area? I'm not sure.
It doesn't apply. It wouldn't apply.
So that officer has to be on the investigative team investigating this subject for this to be enacted.
That is
During-
correct.
How do we know that for sure? Where is the language that says that?
Because the law enforcement officer knew or should have known that the person is a victim, witness, or suspect in the investigation. Oh, and these amendments were put forth by Senator Cassidy during the committee hearing. So
Yeah.
I'll mention that as well.
Okay, so your thought is that if the person was under investigation in another location, then the officer wouldn't have known or should not have been expected to have known that the person was under investigation.
Right, and the officer wouldn't be involved in that investigation, and therefore, if they both consent to be in a relationship with one another, then it's perfectly fine.
Okay, all right, yeah, I like this as well, okay.
Delegate Grammer.
Thank you, Mr. Chair. Delegate Williams, so just to clarify, in saying if a law enforcement officer knew or should have known. I guess that's for the case that for whatever reason, they did not know that this person was involved in the investigation. Is that what we're getting at here?
That is correct.
Okay, thank you.
All right. So there's a motion and a second on the first of the two amendments from Delegate Williams. All in favor of this amendment, raise your hands. Anyone opposed to this first amendment? All right, seeing none, the First Amendment is adopted. We didn't see Max Lopez's hand. So that First Amendment is adopted. Now for the Second Amendment, which is perhaps more interesting. Delegate Moon, would you talk about what your amendment does?
So since we had this bill last year, we have been contacted by some advocates concerned with the tail end of the bill, where it discusses exceptions to the law for certain prior law enforcement relationships. And so look, here's the concern, that essentially, if we have that language in the law, it requires someone who's alleging assault or something from the police to have to bring, they would have to go to court into a hearing to discuss whether, in fact, that prior relationship was legal, things like that, and the history sort of comes in a improper way. And so it was suggested that maybe we didn't need to put that language in there. And so we went back and forth on this for a long time. And ultimately where I landed on this was the scenario where the prosecutor is going to be charging two, law enforcement officers or whatever that are in a consensual relationship with a crime under this language would be so unlikely. But the likelihood of the victims being made to come in, and if consent is going to be the defense, and deal with that kind of testimony seems pretty likely to occur. So it would be, we're essentially being asked to create this extra process and hurdle or hearing in order to satisfy, I think, what's a very unlikely scenario. So that would be my case for just simplifying the bill and removing that language.
All right, is there a motion first on Delegate Moon's amendment?
Move the amendment.
Amendment's moved. Is there a second?
Second.
Okay, so with that, we'll go to discussion on the amendment. That's Delegate Arakan first, then Delegates Cox and Grammer. Delegate Arakan.
Thank you, Mr. Chair. So your idea is that we should get rid of all of, on page 3, number 2, get rid of all, is that where we're starting? I'm trying to find out on page 2. It says on page 2, you're also striking something. Page 2, line 29. Okay, here's where the exceptions start.
Right.
Okay, so
exceptions.
So you're gonna
accept. Yeah.
Okay, and that was because which advocates were worried about this?
Delegate Moon.
So there's a group that I think they're called Power. They work with sex workers and other victims, and so they raised a particular concern with that clause about creating an exception that they thought was going to raise that issue about having to bring in evidence about whether the prior relationship was legal and what does that mean, and does that then bring in past sexual history and things like that. So we started having conversation trying to imagine the scenarios where this law is going to be used. And I guess to the officer's concern here, I'm just not sure what the case is that they think is going to be brought against them in a scenario that we would think is unfair.
But we're making this
It
a
seems a little
crime,
bit simpler
right?
to just say, let's be professional about things, and people shouldn't be having sex with, the class of people involved in these investigations. And let's just do like many workplaces and avoid it.
Well, it's not like okay, I get that, but this is not just between officers and people in the investigation. It could be between two officers. I have lots of officers that are married in my area.
I guess that was my point. Like, who's bringing that case? And I guess my point is, for that unusual scenario where we think some goofy state's attorney is going to bring a case against the two officers that are married or dating and have some tangential involvement in the same case, which they shouldn't, by the way. They should avoid that. But let's just say we get there and it's no harm, no foul. Again, so that rare scenario where we think there's a prosecutor out there who's bringing that case, we're going to now create this extra convoluted process where we are having people bring up all this sort of past sexual history and have to qualify that it was not or was a legal consensual relationship. So again, we just went back and forth on this. That's ultimately where I landed on that balance of concerns. So
okay, and the Senate did not take up this amendment, so we would be out of form with the Senate if we approved this.
We would not be aligned with the Senate. It would go to conference or something, we'd have further discussions between now and, both bills are going to pass before crossover. So there's an opportunity for plenty of time to figure something out and figure out the differences.
Okay, I don't know how I feel about that. I'm not sure if I like the amendment.
Okay, Delegate Cox actually was first. So Delegate Cox, then Grammer, then Malone.
Well, I just wanted to echo, I think Delegate Erickson hit the nail on the head. There's officers that work as teams. There's also officers that, have relationships or are married to social workers and may or may not be knowledgeable of the situation. So I just would think it would be setting potentially those people up for a lot of concern.
Delegate Malone.
What was the JPR's vote with their amended bill? Does anybody know?
I don't know, but if you'll give me a second, I'll start to look at it while we hear from Delegate Cardin, if you don't mind.
I don't mind.
All right, that's fine. Delegate Cardin.
Thank you, Mr. Chair. For Delegate Moon, does this deal with the scenario that I was suggesting where, if there are two people that are engaged in a sexual relationship, two officers, and one is going to be required to testify about the actions of another and managing the other officer, that is fodder for the defense to be able to rip a case apart, which is why I think we just should make it clear that during the course of an investigation, if two officers are involved with each other, they should just not be involved during the course of that investigation, or the chief of the police should make sure that they are not doing it together. They're not working together on a case if they're sexually involved. To me, that's the scenario that we ought to make sure we're dealing with. Does this deal with that?
Yeah, I think you're getting right at the heart of the matter. And again, let me put it back to the committee to just put in your head what the case is going to be where there's a question about consent. It could be an officer on the vice squad has sex with a sex worker. And now there's a question about consent. And the officer saying, what? We had a prior, she consensually did something. We had a prior legal sexual relationship. And I guess the point is, it seems a heck of a lot simpler to just write the law simply and say, we don't do this. And to the extent there's some concern that, bona fide consensual couples going to be dragged into court by state's attorneys like our chair, I don't think so. And so I think that these are the things.
Thank you for that compliment, by the way. Thank you very much for that compliment.
They're a very reasonable bunch of people most of the time.
I'm going to go back to Delegate Malone, then Delegate Bartlett, and I think Erican coming back, but Delegate Malone.
I see that it was
It was
unanimous
11 to
on
nothing and 47 to nothing. It was unanimous both times.
Yeah, I just think it should be noted in this weird year, adding this amendment may kill the bill.
Delegate Bartlett.
Thank you. I don't understand this amendment. And I've read it a few times. I don't understand what it's doing. I see a list of cases, a list of crimes. What is the list of crimes for? What is that?
No, Delegate Bartlett, you might be looking at the amendment that Delegate Moon is putting in on House Bill 489 as opposed to the amendment.
Oh, okay, because I was trying
411.
411.
Yeah, this is 411, not 489.
So, okay, so just this little bit here. Okay,
Yeah.
Thank you, because that's why I was confused. Thank you so much.
All right, Delegate Erican.
Thanks. So I posted in the chat, but like the idea that Delegate Cardin brought up that we should just say, like, if you're in an investigation, you don't do anything, like these investigations can take months. So should married people not be having sex for months? I mean, I understand the idea that, like, let's just try and make it simple, but this is way more complicated than that, in my opinion. And yeah, I'm not seeing how this amendment makes it clear. I think it makes it, plus we don't want to weaponize the law. I mean, sure, we have, first of all, you guys disagree with the state's attorney all the time. Let's not lie. You're like, we love state's attorneys. Just kidding. They suck. We hate their opinions. Anyways, just saying. But some of them could be vindictive, and they could have a bad case where a police officer messed up their case and they're mad about it, and they could certainly become vindictive. And we do a lot of stuff to avoid making laws that can be weaponized against otherwise innocent people. That's exactly what this amendment will do. It offers an opportunity for somebody vindictive to take it out on otherwise innocent people. So that's my problem with the way this amendment works. It doesn't work. Thank you.
All right, Delegate Nicole Williams, then Grammer, then I'm going to call a question.
Yeah, I just wanted to comment, like Delegate Moon said, there were some advocates who were concerned about the language. People who previously might have been in unfortunately human trafficking situations where, they felt as though this language would cause them to have to revisit kind of their prior acts and conduct and be discriminatory against those individuals. So I just, and we tried to work with the advocates. We had a couple of meetings with them to try to see if we could come up with some alternative language that would satisfy all parties. And I just took the approach kind of like, if you're in court and you get a judgment and both parties are unhappy with the judgment, then it's probably the right judgment. So that's where we are, and that's why this came up.
All right, I'm being summoned to go to the State House. Delegate Conaway with your comments, and then we're calling it on the amendment, and then we're going to move to the bill.
I thought, Mr. Chairman, that Delegate Cox should say what he wrote, and I went to look it up to see if it was in the chat, but it's not. So that's my comment.
All right. All right, we're on the amendment. This is Delegate Moon's amendment, and because I believe that this will be contested, I'm going to call a roll call. We have a motion in a second, and here we go. The Vice Chair.
Yes.
Delegate Anderson.
Yes.
Delegate Erican.
No.
Delegate Bartlett.
Yes.
Delegate Cardin.
Yes.
Delegate Conaway.
Yes.
Delegate Cox.
No.
Delegate Crutchfield.
Yes.
Delegate Deborah Davis.
Yes.
Delegate Juanica Fisher.
Yes.
Delegate Grammer.
No.
Delegate Griffith.
No.
Delegate Rachel Jones.
Yes.
Okay. Delegate Lopez.
Yes.
Delegate Malone.
No.
Delegate McComas.
No.
Delegate Moon.
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
No.
Delegate Williams.
No, and am I able to explain my vote?
Very briefly, yes.
Just because this language that was there was a compromise that I worked out with the chiefs and sheriffs, and I don't want to go back on my word to them. So that's why I'm voting no, but I absolutely understand why people are voting yes.
I got it. The amendment is adopted 12-8. We're on the bill as amended. Is there a motion?
Move the bill.
There's a motion for a favorable and a second. Discussion on the bill as amended. Delegate Arakan.
Mr. Chair, I fully had intended to vote for this bill, but given the fact that we're now going to criminalize legal sexual relationships between married people, I will be a hard pass on this one.
All right, Delegate Conaway,
Yes.
are you voting on the bill or? Oh, okay, that's fine. No, I'm not calling the bill yet, but there's a motion for a favorable and a second. We'll do the roll call. The vice chair,
Yes.
Delegate Anderson,
I'm going to go with Conaway.
is that a yes?
Yes.
Delegate Arakan is a no. Delegate Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
No.
Williams.
Yes.
All right, 13-7, the bill passes. Look, again, I think there's going to be further discussion on this issue. We're getting a ball in the air. The Senate's got a ball in the air. We will find a way to conclude this one way or the other. I call to the State House. This creates a problem. So I am going to come back we will come back at 3:20. I need 20 minutes to get there and back. Well, let's just do a flat 3:30. 3:30, and we have 4 more bills. I don't believe they will take very long. So we will recess the voting session for 30 minutes. Thank you very much.
Good luck handling that bill on the floor.
Thanks.
Arden, stop being like that.
Yeah, we should have gotten Delegate Williams' opinion on the amendment before we push that.
No, I
Are you all still live?
Excuse me.
Are
I
you
think we're
live?
still live. I think we're still live.
That was quick.
We're still live, but we'll still come back at 3:30 and go from there. members of the committee would please come back. It is 3:30. We're going to go ahead and get started again and finish the rest of the voting list, please. Still missing a few people.
Sorry, Mr. Chair.
You're fine. Delegate Grammer, Cox. Who else are we missing? We need Delegate Conaway.
I'll check and see if he's still an ENT, Mr. Chair.
Oh, he might still be an ENT. Yeah, well, we're just going to have to keep going. I don't think there's anything here too incendiary, but we'll find out. All right, we're coming back. It's 3:32. This is the House Judiciary Committee. We're going to come back for voting session now. 4 more bills. House Bill 445. There is an amendment from.
Move favorable.
I'm sorry? Oh,
I
sorry.
said move favorable.
There's a motion for a favorable. Is there a second?
Second.
All right, there's a motion for a favorable and a second, except we can't do that yet because there's an amendment. So we have to do the amendment first. The amendment is from Delegate Dumais, and I think it addresses some technical changes that needed to be made, and it includes citation in the language for. Okay, Claire, I'm sorry. Let's just go ahead. Claire, can you tell us what Delegate Dumais' amendment does, please? Is Claire on?
Hello, sorry, I had problems unmuting. Delegate Dumais' amendment makes conforming changes relating to an application to the governor for extradition of a person charged with a crime by citation in the state. It's just technical.
All right, so this is a technical amendment. Is there a motion on the amendment?
Can I ask a question?
Yeah, go ahead.
A person who is arrested in another state for a crime that's chargeable by citation doesn't have to be, there's no extra for that. You get extradited only for crimes for felonies, right, Claire?
Well, presumably, apparently, it's my understanding this was suggested by the State's Attorneys Association. And I assume that now that we're authorizing charging by citations for more serious crimes, including drug possession, that maybe this might be the subject of an extradition, but I don't know for sure.
Well, I know for sure, and I think our chairman and anybody else that practices criminal law, that another state can hold you at another state's request for a felony, but not for anything less. And so that's just the law.
Trying to get to the law at the moment.
Who said that?
this is the chair. I'm trying to get to, where we are here. Oh, boy. One moment, committee. Just need to make sure that I'm looking at the right part of the code.
I don't even see when the return, let me mute.
So we're in. Claire, is this an amendment to 9-123 of the criminal procedure article, or what am I missing here? No.
Yes, 9-123 of the criminal procedure article. It's that particular section is not limited to felony.
Oh, I see.
What's the new language, Claire? I mean, I see everything underlined, but
The words in bold.
oh, I'm sorry. Yeah, I couldn't see the whole scrolling down part. I can scroll this thing. I can't scroll it.
You can't scroll it on the screen, no.
Right.
But if, Dylan, you can go to the third page of Delegate Dumais' amendment, please.
Citation stating.
That's where it lives.
With which.
Right, so all it's adding is, it is a technical amendment. It's basically saying that if they were to seek extradition from somewhere else for, I guess, a crime that was charged, an incarcerable crime charged by citation, that they would have to include that in the application for extradition. I mean, I guess
all I'm saying is that this basically applies to crimes that were committed in Maryland, where the defendant is now in another state and is being held by that state.
Yes.
That's where extradition occurs. And there's no crime, there's no felony that can be committed in Maryland that you can charge by citation. And therefore, the person being held in another state is being held for a misdemeanor. And another state can't hold a defendant only charged with a misdemeanor.
Delegate Anderson, where does it say in the law that they can only seek extradition for a felony?
Well, it's in my brain, but I'll have to look it up now. This is
because in the application for extradition, I don't believe it specifically indicates that it can only be a felony. All right, why don't we do this? Mostly because I think we could linger on this for a while. I'm gonna hang on to this bill. Let's hold on to 445, just because the other bills that we've got before us are relatively straightforward. We can do those, but we're going to try and address the issue that's raised with 445 as to, why that amendment is needed. And I'll talk to Claire, and we'll talk to Delegate Dumais and get the genesis of that amendment. I thought it was a little more straightforward than perhaps it is. And so we'll get that answer to Delegate Anderson too. So let's go to House Bill 449.
Okay.
House Bill 449 is Delegate Bartlett's bill. There are no amendments that have been submitted for the bill. Is there a motion?
Move favorable.
There's a
Second.
motion and a second. Is there any discussion on House Bill 449 that I think just makes a word change in the marriage licenses from party to party 1 and party 2? That's what the bill does, Delegate Bartlett?
That is what the bill does, and it also allows for the clerks to have written or electronic records of marriage histories. So it's not limited to electronic, it's written or electronic.
All right. Any further discussion on 449? Delegate Cox.
Thank you, Mr. Chair. And I just wanted to reiterate what I said during the hearing, and that is there shouldn't be any objection to adding an opt-in clause for these terms. The problem is when you eliminate husband and wife from the legal records, you're potentially eliminating a lot of opportunity for historical analysis and genealogies and such. And so I'm very much opposed to such a major change, I think, long-term in the law, and I'll be voting no on this.
Okay.
Just, I wanted to respond if I may.
Delegate Bartlett, go ahead.
And I understand that, Delegate Cox. There is it is always available to write in parentheses, if you prefer husband, or if you prefer wife, or whatever you prefer. That's always an option. You can do that in parentheses. So that option isn't taken away.
If I may, does that allow it though to be actually legally and historically recognized? In other words, the databases and the official records are going to be party 1, party 2, whether or not your personal license says something is different, I think. And that would be my broader concern.
Okay, well, thank you. I appreciate your concern.
Is there further discussion on the bill? Delegate Griffith.
I just want to follow up on Delegate Cox's question. It was a concern, but it didn't occur to me right now about the question about that. With party 1, party 2, if an individual does decide to write in whatever their preference is, would the record reflect that, or would the record still reflect party 1, party 2?
Delegate Bartlett.
I'm looking at testimony now because this was a question that was asked during the hearing. And I'm looking now to see what the clerk's response was. It was an adequate response at the time, and it made sense.
Well,
But
and so
right off the top of my head.
I'm sorry, I would just say, I think anyone, no matter what your preference, would want their preference in the record, regardless. So I would like some clarification on if there's a way to have their preference recorded in the record regardless of preference. Because I don't care what your preference is, I think all of us would want our particular preferences in the official record. Is it too late to try to do an amendment to that end to try to make this a better bill for everyone?
We did not receive any amendments in enough time to be distributed. Every member, I mean, I hate to put it this way, every member has one hold that they can use one time during the session on one bill. It's whether you would want to do that for this one or not is up to you. That's where we are with this right now. Delegate Arakan has a comment, then Delegate McComas.
Yeah, thanks. So I spoke with our clerk and he said that they don't currently use husband and wife in the system anyways. I don't think it doesn't come out like that. it comes out just with the names printed. There's no identifying gendered language on the actual document at all. So, and he voted for this in our, they had like a coalition. It was a unanimous vote from the, far left to the far right on changing this bill the way that it's drafted currently. So I just decided to throw that out there.
That was the answer actually that came out of the hearing. Thank you, Delegate.
Yeah, there's no gendered language on the actual documents at all, just the application paper. So.
Delegate McComas has lowered her hand. Never mind. All right. All right, so the bill is set for a favorable with a second. I don't see anybody else who wants to make a comment. So we'll go ahead with the roll call. The Vice Chair?
Yes.
Anderson?
There's a party over here. Yes.
Chair.
Delegate Arakan?
Yes.
Bartlett?
I had some music. Yes.
Cardin?
Yes.
Conaway?
Yes.
Cox?
No.
Crutchfield?
Yes.
Deborah Davis?
Yes.
Juanika Fisher?
Yes, Mr. Chair.
Grammer?
Yes.
Griffith?
Yes.
Rachel Jones?
Yes.
Lopez?
Yes.
Malone?
Yes.
McComas?
Yes.
Moon?
Yes.
Shetty?
Yes.
Cham?
Yes.
Williams?
Yes.
19. All right, we're going to go now. Delegate Pippi's Bill 477. There are no amendments that have been submitted.
Favorable.
This motion for favorable, is there a second?
Second.
And a second. All right, is there discussion on House Bill 477? I think it aligns the warrant process for a cell site simulator to be able to be done electronically, just as search warrants can be done. Delegate Deborah Davis.
Thank you, Mr. Chair. I'm looking at my notes, and I said I was in support of the bill, just that it had witness problems. Sponsor problem.
I think I would tend to agree. He abandoned us. And I think that we could engage in a long discussion of our hurt feelings and the pain that he's caused, really. But instead, I think I'm calling a roll call. Does anybody else have any comments regarding the bill?
I had those same notes, Mr. Chair.
Do you? Does everyone have those same notes?
Yeah.
Yes.
Everyone has those same notes. It's remarkable. Unanimity.
Favorable.
The Vice Chair.
Despite my objections, yes.
Give this kid a complex. Anderson.
My music ran out, but yes.
Arakan.
Yes.
Bartlett.
Yes.
Cardin.
Yes.
Conaway.
Yes.
Cox.
Yes.
Crutchfield.
Yes.
Deborah Davis. Deborah Davis. Yes. Okay. No, we can't hear you. You got to unmute.
Yes.
Okay. Juanika Fisher.
Regretfully, I'm voting yes.
Grammer.
Yes.
Griffith.
Aye.
Oh. Rachel Jones.
Yes.
Lopez.
Yes.
Malone.
Yes.
McComas.
Yes.
Moon.
Yes.
Shetty.
Yes.
Cham.
Yes.
Williams.
Yes.
That's 20. And several statements of regret.
Maybe we can change sponsorship to the committee. You could just make it a committee bill.
the bill is done. We're not hearing any further amendments right now. House bill, he's going to watch this. He's going to have a complex, and I'm going to have to deal with that now. Just want you all to know.
He deserves it.
Grammar says he deserves it.
He needs to shave too.
House Bill 489, please. Has an amendment. Delegate Moon, why don't you tell us what the amendment does, please?
The bill, as introduced, allows prosecutors to apply for a wiretap order, and there's a specific list of crimes for which this is allowed, and this would add misconduct in office to that list. What the amendment does is that list is paralleled in a separate part of the Courts and Judicial Proceedings article that excludes a list of crimes where the wiretapping would otherwise be subject to a criminal penalty. So it would make sense to put the same list of crimes on both 10402 and 10406. So I move the amendment.
Motion on the amendment. Is there a second? And a second. Any further discussion on the amendment? Seeing none. All in favor of the amendment, please raise your hand.
Oh, Malone is,
Well, Malone, were you wanting to be
I
recognized?
was waving yes.
You're waving yes. And
For the state's attorney, because my memory is that there was a kumbaya moment between Schellenberger and Moon on this one. I'm just making sure that that kumbaya moment is still there with this amendment.
it continues apparently with this amendment. We're all surprised. All right, so the amendment is adopted. We're now on the bill as amended. Is there a motion?
Move the bill as amended.
Move favorable. Is there a second and a second. Any further discussion? Delegate Grammer.
Just a brief question for Delegate Moon. Can you help me more clearly understand the scope of misconduct in office? I know it's a common law crime.
So I'll give you two examples from recent memory. One is very recent. It was somewhere in Anne Arundel, I want to say the police were actively choosing not to investigate sex assault. That could be a misconduct in office allegation. And then the other, also from Anne Arundel, was when the county executive was sort of misusing public resources and having law enforcement investigate political opponents.
Yeah, but I mean, I support the bill, but just to be clear, this is very broad. I mean, misconduct in office can apply to a lot of different things. I believe in case of Anton Black, when the police leadership didn't submit the background of that police officer, they actually got him on misconduct in office, if I'm not mistaken. So this is very broad.
So I agree with you, and actually would say if you want to work on a project together next session, one of the issues I flagged here is I personally disfavor common law crimes. I'd rather we enumerate exactly what we mean in the code. So if you want to undertake that project together, we might have something to work on next year.
Sounds good. Thank you.
Chair is noting Delegate Moon's interest in that. And yeah, putting case law in the law is probably a bad idea. Anyway, are there any further comments? Seeing none, we're on the bill as amended. There was motion and a second. We'll go and have a roll call. The Vice Chair?
Yes.
Anderson?
Yes.
Erican?
Yes.
Bartlett?
Yes.
Carden?
Yes. Kumbaya.
Conaway?
Yes.
Cox?
Yes.
Crutchfield?
Yes.
Deborah Davis?
Yes.
Juanica Fisher?
Yes.
Grammer?
Yes.
Griffith?
Yes.
Rachel Jones?
Yes.
Lopez?
Yes.
Malone?
Yes.
McComas?
Yes.
Moon?
Yes.
Shetty?
Yes.
Cham?
Yes.
Williams?
Yes.
All right, 20 votes. That concludes the bills we're going to vote on today. The following bills are going to subcommittee, and we're going to try and set up meetings. And the council are going to be trying to set up meetings here in the next week. There's Max again. The Criminal Law Committee headed by Delegate Moon is going to hear House Bill 88 from Delegate Brooks, House Bill 128 from Delegate Stewart. It's a hate crimes bill. 231 from Delegate Palakovich Carr. 234 from Delegate Williams, and that is her service animal bill. Civil Law is going to hear two bills for starters.
Mr. Chairman?
Yes.
When you say the numbers of the bills, can you just say a little bit about the bill?
Okay. House Bill 88 is going to employee assistance programs for police officers. 128 is, I think, extending the hate crimes law to further protect people who are, I don't think it's solely transgender, but it deals with identity. 231, it's the brain just stopped. 231 is the panic defense. 234 is harm to service animals. House Bill 23 goes to civil law. And this is regarding limiting the information available. I think it's pictures. I know we talked a lot and heard a lot about whether ICE would have access to photographic evidence from MVA. That bill goes to civil law. 260, Delegate Fisher's bill on jury service. The Family and Juvenile Committee will hear House Bill 93. Delegate Henson's bills on local youth violence review committees. House Bill 343 regarding sentencing. This is the consecutive or concurrent sentences for non-payment of child support. And 646, Delegate Valentino Smith's bill on, it's a memorandum of understanding with the Military Family Advocacy Program. Public Safety is hearing 670, 671, which are the two police reform bills. They're also going to hear House Bill 89, Delegate Wilkins. Hang on, Delegate, make sure you're muted, please. Somebody else is talking. Delegate Fisher.
Oh, you're right.
Delegate Fisher. There you go. Delegate Wilkins' bill on diminution credits to public safety. 306, Delegate Jackson's bill making a false statement to a law enforcement officer if it is based in animus, a hate crime. And 372, the decriminalization bill from Delegate Moon, or drug paraphernalia decriminalization bill in 372. Is that it? There are now questions. Delegate Grammer? Delegate Grammer, were you, that was just your hand up from before? Okay.
I'm good, thank you.
Okay, Delegate Williams, Delegate Cardin after that. Delegate Williams.
My only question I had, Mr. Chair, 445, are we moving that to a different day then?
Yeah, we'll move that to the next voting session. We'll
Okay.
move that to the next voting session. Delegate Cardin?
Thanks. There was a bill that was heard, I think, in Health and Government Operations dealing with wills and advanced directives. They took out the advanced directives, it's only dealing with wills. Is that being reassigned to us? Any ideas? I mean,
I don't know, but if you can get me a bill number, we can look into it.
Delegate Cardin, I can tell you it's not. We already tried.
Oh, we did?
This is the one with the notary piece?
No, this is not, well, there's a notary one, and then there was one that had advanced directives in it, and then the member removed that, and because it went in with advanced directives and was amended out, it has to stay in HGO.
Right, so we can't take it now that they took it out.
Yes.
Okay.
All right. Are there further questions? All right, we will begin to have voting sessions a little bit more frequently. My plan right now, though, is to have a voting session next Friday. Next week is busy, especially on Tuesday and Wednesday. Tuesday and Wednesday are likely late nights. The other ones should not be as bad, he said wistfully. All right, thank you all very much for all your work this week, and we'll see you next week.